Hello, ladies and gentlemen. My name is Isaac Christopher Lubogo. Today, I want us to discuss something that have to do with treaties and a little bit in terms of international law. What are treaties? Treaties basically are formal agreements between two or more sovereign states or international organizations, usually governed by what they call international law. So they are sometimes referred to as international conventions or agreements or accords. So what happens is that treaties basically play a fundamental role in the field of international law as they actually establish what they call legal obligations and the rights for the parties basically that are involved. So I'm going to discuss to you certain key aspects, what I would consider key characteristics or aspects of treaties under international law. Number one is what we call voluntary consent. What happens is treaties, or basically states, not treaties, states enter into treaties voluntary, and their consent is fundamental in terms of the principle under international law. So states must actually express their willingness to be bound, usually by the terms of the treaty, through a formal act, usually such as signing or ratifying or acceding to the treaty. So that's one way in which people or organizations or entities enter into treaties. Another is by way of what they call written form. So treaties are basically written agreements, and their terms are documented in a written text. So this text may actually include provisions detailing the right and obligations of the parties, as well as procedures for dispute resolution and enforcement mechanisms. Another way is by what they call binding legal obligations. Now listen, we're going to go through quite a lot, so bear with me. Binding legal obligations: once a state becomes a party to a treaty, it's legally obligated to comply with the treaty's provisions, and usually failure to do so can actually result in what they call international legal consequences. Other ways in which entities or whatever countries entered into treaties is by way of what they call parties. Parties, here, what I mean is that treaties can actually have multiple parties, and each party agrees to be bound by the treaty's terms. So some treaties are bilateral, meaning they are between two states, while others are actually multilateral, involving more than one or two states. Yeah. So that's something you must comprehend. And then another way is what they call ratification and entry into force. So what happens is that after a state signs a treaty, it often needs to go through what they call a ratification process, which may actually involve approval by a country's legislative body. So once the necessary internal procedures are completed, then the state can actually deposit its instrument of ratification or accession. So what happens is that the treaty enters into force once a specified number of states have actually ratified it or on a predetermined date. So that's substantially very important for us to comprehend. Another is by way of what we call reservation and declarations. Here, states may actually make reservations or declarations when becoming parties to a treaty, which can actually modify their obligations under the treaty. So these reservations must actually be accepted by other parties to a treaty for them to be valid. So that is something that you also need to comprehend. Another is by way of amendments and modifications. So some treaties usually allow for what they call amendments or modifications to their provisions, and these changes typically require the consent of the parties that are actually involved. I'll discuss the legal framework in terms of treaties, and it's quite extensive. I pray that I have the strength to go through. But another way is by way of interpretation. So what happens is disputes over interpretation of the treaty provisions can actually be resolved through what they call various means, such as negotiation or arbitration or adjudication, or even by international courts or even tribunals. That is something you may also want to comprehend in terms of that component. And then you could also argue in terms of treaties by way of entering into in terms of termination or withdrawal. Treaties can actually be terminated or withdrawn from according to the provisions specified in the treaty itself, or through maybe customary international law, or where states may also negotiate and enter into supplementary agreements to modify or replace even existing treaties, as it were. That is something you must comprehend as well. So listen, one thing you must understand when you're arguing or discussing this concept of treaties is that treaties basically covers a wide range of subjects, including trade, human rights, environmental protection, arms control, and more. And they provide a framework for cooperation and the establishment of rules and norms in the international community, contributing to stability and what they call predictability in international relations. I'll try as much as possible to summarize the authoritative legal authority in terms of treaties, you may want to look at what they call the Vienna Convention of the Law of Treaties, which was of 1969. I'll try to go through several parts. Let's argue part one. Part one basically talks about the introduction in terms of Article 1. So the treaty basically applies to treaties made between states. When you look at Article 2, it outlines the definitions of what words in a treaty mean. And Article 3 outlines what this treaty does not apply to. So the treaty does not actually affect the legal force of any agreement already concluded between states. That is something you must understand. So the application of rules and the procedures for treaties outlined basically in the treaty does not affect agreements already concluded between the states, which are they themselves subjected to international law. When you look at Article 4, you have to comprehend that the treaty only applies to treaties which are actually made after the treaty has actually entered into force, and I'm talking about the Vienna Convention. So anything made prior to the entry into force of that particular treaty would be subject to international law independently as far as the treaty is concerned. When you argue Article 5, the treaty basically would apply to any treaty adopted within an intergovernmental organization. So you must comprehend that. Now let's argue Part 2. Part 2, basically you argue in terms of conclusion and the entry into force of treaties. And if you look at Article 6, it argues that all states possesses the capacity to conclude a treaty. Article 7, a person can actually represent the state for purposes of adopting and authenticating a treaty if that person has appropriate full powers. So if a person, for example, appears from the practice and intentions of the state to be representing the state, this person has full powers. So the idea is that without having the full procedure of full powers by virtue of their function, the following persons are actually considered to be able to present the state in terms of people like heads of state or heads of government and even ministers of foreign affairs, in terms of conclusion of these particular treaties. So even heads of diplomatic missions in terms of adapting the text of a treaty between two states, for example. Sometimes even representatives of states to an maybe governmental conference or organization that can adapt the text in a treaty that can, for example, in a conference or an organization. Now, when you look at Article 8, Article 8 talks about concluding a treaty which is not under legal effect if performed by a person who is not considered as having full powers. When you argue Article 7, unless if it's afterwards confirmed by the state, that's an argument that's propounded by Article 7. And then Article 9, the treaty is adopted if it has actually consent of all states responsible for drawing it up. So if it is not consented by all, and it's a treaty held, at an, for example, intergovernmental conference, then the treaty is adopted if it has 2/3 of the majority. Now, when you look at Article 10, the text of the treaty basically is to be established becomes authentic, especially if it's agreed upon by the parties participating in its drawing up. When you argue Article 11, the consent of the state bound by the treaty is actually expressed by form of signature or even exchange of instruments, sometimes acceptance or even approval or accession or ratification or by any other means agreed. When you argue Article 12, a state is basically bound by consent to the treaty by signature. If, for example, the treaty states that signature shall have, effect, so the participating states negotiated, this particular signature shall have that effect. So the effect is that the state intended to have that effect through basically the full powers of the signatory if it was made, explicit during the negotiation. So that is extremely important. When you look at Article 13, a state is bound by consent to the treaty by exchange of instruments if, for example, the instrument provided that it will have that effect. Yeah. So states involved agreed that maybe such instruments will have, that effect. Then it becomes binding. When you argue Article 14, a state is bound by consent to the treaty by ratification in terms of acceptance or even approval. If, for example, the treaty states that such consent will have the effect in terms of negotiating, as far as the states are concerned, when they agree in such of a consent, then they will have that effect. So the argument here is that a representative of the state has signed the treaty subject to maybe ratification or acceptance or approval. So the state intended to sign the treaty subject to that ratification or acceptance or approval appearing from the full powers of the signatory, or if it was made, for example, explicit during the negotiation. That is important as far as Article 14 is concerned. Article 15, usually a state is bound by consent, to the treaty, especially by accession. If, for example, the treaty states that such consent will have that effect, so negotiating states, agreed that such consent will have that effect. So all parties agree that such consent will have that effect. If you argue in terms of Article 16, a state usually is bound by consent to a treaty by exchange of or deposit of instruments or ratification in terms of approval or even accession. For example, when they have actually been exchanged by the states involved. So they have actually, sometimes when they have actually been deposited by the depository. So the argument here is that a state's function to the states involved or even the depository has to be taken into action. Look at Article 17. A state is bound by the treaty only if the treaty permits or other states involved agree. Remember that. So the consent of the state is bound by the treaty, which allows choice in terms of differing, provisions in terms of effectiveness. So only if it is clear, for example, that provision in terms of consent relate to it. Article 18, the state should actually refrain from acts which defeat the object and the purpose of the treaty. When, for example, if it's bound by the treaty or by consent or by any acts under the act. In terms of Article 11, unless the treaty has actually made clear intentions or not to be part of the treaty, it has consented to be bound to the treaty awaiting its entry into force. In terms of Article 19, a state may actually form reservation, for example, when signing or even ratifying or even accepting or even approving or even acceding to these treaties, unless, for example, if the treaty prohibits reservation and the treaty states only specific reservations which are permissible, which does not include reservation in question. So the reservation is not compatible with the object and purpose of the treaty. That is something you must comprehend. When you look at Article 20, acceptance of and objection of reservations inter alia, the argument here is that the reservation authorized by the treaty does not actually require acceptance by any other states unless the treaty mentions it so. So from the object and purpose of the treaty, it appears that the treaty is in its entirety between the parties, becomes an essential condition of consent. If you're arguing in terms of reservation, it requires acceptance by all the parties. Now, if, for example, a treaty is an instrument of an intergovernmental organization, a reservation requires acceptance from an organ in terms of that organization. Yeah. When you argue Article 21, the legal effects of reservation and objections to reservations, the argument here is that the reserving states modifies its relations with those, in terms of a party to the treaty with the reservation that it relates to. Yeah. So those a party to a treaty consequently modify its relation with the reserving state that has actually the provisions of the treaty that the reservation relates to. So the particular reservation from reserving state does not usually apply to all states a party to the treaty, unless a state also submits the same reservation. So if, for example, the state objects the reservation of the reserving state but does not oppose the entry of force of the treaty between itself and the reserving state, then the reservation in this case does not apply between the two states. So you must comprehend that. Now, putting it the other way, if, for example, a state disagrees with the reserving state's reservation and the treaty enters into force, then the reservation in question does not actually apply between the two states. Yeah? When we argue Article 22 in terms of withdrawing reservation and objections to reservation, so unless it is made explicit in a treaty, the reserving state may actually withdraw their reservation at any time. Yeah? And the argument here is that the consent of a state of the reserving state's reservation in most cases is not required. Now listen, an objection to a reservation may actually be withdrawn at any time. The argument here is that the withdrawal of reservation becomes valid only when the states party to the treaty have been notified of it. Okay, and then the withdrawal of, for example, an objection by a state to a reservation of a reserving state becomes valid, for example, when notice has actually been received by the receiving state. Okay. Now, if you are to argue in terms of Article 23, in terms of procedure and reservation, a reservation in terms of objection to reservation or even acceptance of reservation must be in writing and informed by the parties to and also entitled to the treaty. And the argument here is that reservation must be confirmed by the reserving state if formulated when signing the treaty awaiting its ratification or even approval or even acceptance. So the argument here is that an objection to a reservation or acceptance of reservation made prior to signing of the treaty in this case does not require confirmation. Okay, and then in terms of withdrawing reservation or an objection to reservation, it must be made in writing. When you look at that article, now if you argue Article 24, entry into force, for example, a treaty enters into force on the date mentioned on the treaty or at a date that the participating state agree. Yeah. So failing on above, the argument here, the entry into force of the treaty begins when the parties states give consent to be bound by the treaty. If the state consents to be bound by the treaty after it has already come into force, the entry into force of that state starts from the date it gives that consent, or at the date mentioned on the treaty. Please remember that. Now listen, other provisions of treaty such as authentication, things to do with the reservation and function of what they call depository, apply from the date the treaty is actually adopted. Please understand that. Now when you argue Article 25, part of the treaty is applied pending its entry into force if the interests so provide for in terms of the participating states, if they agree to do so. Now let's argue part 3. Part 3 in terms of observance, in terms of application, in terms of interpretation of treaties. Particularly Article 26, what they call Pacta Sunt Servanda, in Latin, agreements must be kept, yeah? So all treaties are binding upon states parties to it, yeah? And must be performed in good faith. When you argue Article 27, a state may not invoke a provision of their domestic law as justification for not performing a treaty. If you look at Article 28, so unless mentioned explicitly on a treaty in terms of acts performed by the state prior to the entry in force of the treaty that are not held accountable to the treaty, what they call non-retroactivity. Yeah, that's something you need to comprehend. If you look at Article 29, the argument is here that unless mentioned explicitly on a treaty, the scope of the treaty covers a party's entire territory. In terms of Article 30, application on successive treaties relating to the same subject matter, for example. So if a treaty specifies that a consent to its compatibility or subject to an earlier or later treaty, the provisions to that earlier date in terms of the later treaty is still applicable. Okay, so if the same states are actually party to an earlier or later treaty, but the earlier treaty is not terminated, especially under Article 59, the provisions of the earlier treaty still apply only to the extent that they are actually compatible, right, with that later treaty. So the argument here is that if parties to the later treaty do not include all parties to the earlier treaty, the states that are actually parties to both earlier and later apply to the above point in terms of the argument that I'm proposing. So if there was one state that is actually a party to both earlier and later treaties, and another which is not party on one of them, then the treaty, in this concept that both states are party to govern their rights and obligations, that is something that you must comprehend. When you argue Article 31, the argument here is in terms of the general rule of interpretation of treaties. The argument is that a treaty shall actually be interpreted in good faith, yeah, in accordance with its ordinary meaning. So in light of its context, the object and purpose of the treaty is important. So the argument here is that the context of the interpretation of the treaty is actually comprised in its text and by its agreement made by states in relation to the treaty. So the context of the interpretation to a treaty is also made in light of any instrument made by one or even more of the parties in relation to that treaty. Yeah? Now listen, apart from what I've talked about, its subsequent agreements between parties in terms of practice by way of application on the treaty and even applicable rules in terms of international law should actually be taken into account when interpreting treaties. Yeah? Now let's talk about Article 32 in terms of preparation of notes of the treaty and also the circumstances that have to do with conclusion that must be taken into account in order to determine the meaning of the treaty. If the interpretation, for example, is ambiguous or obscure or even absurd or unreasonable, that's something you must understand. When you argue Article 33, interpretation of the treaty authenticated in 2 or more languages, for example, here the treaty is equally authoritative in each language unless the treaty makes what? Explicit or otherwise, okay? Or if the parties do agree. So a language of the treaty which is not authenticated is not valid unless the treaty, makes explicit or even if the parties agree, yeah? So in each of the authenticated language, it is assumed that the treaty has the same meaning, yeah? So if both or even all languages of the treaty are actually authenticated, then it's discovered that there is a difference in meaning of the treaty between, the languages involved. The meaning which best fits the object and purpose of the treaty in most cases shall be adapted. That is something you also must comprehend. If you argue Article 34, a treaty basically does not create a right or obligation to a third state without a third state's consent. Okay, in terms of Article 35, for example, if the treaty, intends, for there to be an obligation for a third state, and that state agrees in writing to that obligation, that is acceptable as far as the provision in terms of the treaty. If you're looking at Article 36, a third state may have a right from the provision of the treaty if the parties of the treaty intend for the third state to have the rights, or rights are to be for a group of states or for all the states. So third states usually assent is usually presumed unless the states mentions otherwise. So in exercising a right, the argument here is the state must actually comply with conditions for its exercise as mentioned in the treaty. When you argue Article 37 in terms of revocation and modification of obligations or rights to third states, when an obligation has risen for a third state, look at Article 35. The obligation may actually be revoked or even modified with the consent of the state, party to the treaty, and in terms of the third state. Now, when a right has actually arisen for a third state, in terms of Article 36, the right may not be revoked or modified by the party to the treaty if the right specified or was intended. Yeah? So that is irrevocable and not subject to modification. Please understand that. When you're arguing Article 38, anything as far as Article 34 to 37 cannot be used as being binding on a third state for reason of being not part of the customary international law. Look at, if you're arguing in terms of Part 4. Part 4 will talk about amendment and modification of treaties, especially Article 39, where we're arguing that in case of a treaty involving two states, a treaty may be amended upon agreement by both parties. Now, rules followed will actually entail, as the argument I made in terms of Part 2, if you remember, of that treaty. But when you look at Article 40, amendments of what they call multilateral treaties, the argument here is that any state that proposes to amend a treaty must actually notify all the participating states or to the treaty. So the argument of participating states must have a right to take part in a decision as to the action such as proposal, for example, and the conclusion agreement to amend the treaty. So all participating states to a treaty are entitled to become a party to the amended treaty. And the argument here is a state currently a party to a treaty is not bound by the amendment to a treaty if they do not become party to the amended treaty. Remember that. So after the entry into force of the amended agreement, any new party, to the treaty is considered to be a party to the amended treaty. Yeah? Now, the argument also we need to comprehend that a new party is usually considered a party to an unamended treaty, to those, current parties to the unamended treaty. For example, as these states decided not to be parties to the amended treaty, look at Article 41. Article 41 argues that an agreement to modify what they call multilateral treaties between certain parties, only two of the parties may actually agree to modify the treaty between themselves if the possibility of modification is permitted by the treaty. Yeah? Now, if the modification is not prohibited by the treaty, then the modification basically becomes possible if it does not affect the enjoyment or the performance of the other parties under the treaty. And the argument here is that modification is also possible if, for example, if it does not derogate from the object and purpose of the treaty as a whole. So, two or more parties that agree, for example, to a modification between themselves usually notify the other state's party, to the treaty in terms of that modification. Okay? When you look at Part 5, in terms of invalidity, termination, and the suspension of, or in terms of operation of treaties, basically, if you're arguing in terms of Article 42, validity and continuous in force of these treaties. The argument here is that the validity of a treaty or consent to be bound by a treaty can only be called into question through the articles of the convention. Please remember that. Now, the aspects in terms of the termination, withdrawal, denunciation, or even suspension of operation of treaty can only be as a result of the articles of that convention. When you look at Article 43, in terms of termination or withdrawal, even denunciation, when you're arguing in terms of suspension of operation of a treaty does not affect a state's obligation, to the rules of international law independent of the treaty. So if you look at Article 44, in terms of what they call severability of treaty provisions, a state that invokes a right to denounce or withdraw or even suspend the operation of a treaty does so for the whole content of the treaty unless the treaty allows otherwise, or if, for example, the states party to the treaty agrees. The argument is that the reason for invalidating or even terminating or even withdrawing from or even suspending the operation of the treaty must be given in respect to the treaty as a whole. So if this reason, for example, is due to maybe a particular part of the treaty, then it's not acceptable unless the part of the treaty in question can actually be separated from the treaty as a whole. So the part of the treaty in question is not an essential part of the treaty. Please understand that. Now, being obligated to only the remainder of the treaty is just in all circumstances. Look at Article 45. The argument a state will lose the right to invalidate or even terminate or even withdraw or even suspend the operation of the treaty if, after becoming aware of its facts under Article 46 to 50 and 60 and 62, still expressly agree that the treaty remains valid or by its conduct accepts the validity of the treaty. When you argue in terms of Article 46, a state cannot use the reason that they do not consent to the treaty as if it violates their domestic law, yeah, unless that domestic law is a fundamental importance in terms of that. When you look at Article 47, if, for example, a representative of a state expresses consent of the treaty, which, with a specific exception that, that exception is not ground for invalidating consent of the treaty, yeah, unless the exception was actually notified for participating in terms of the states, yeah. Now, when you look at Article 48, a state may actually give error as a reason, to invalidate its consent of a treaty. If it relates, for example, to a fact or a situation that was assumed by the state, and if this fact or situation is essential in terms of the basis of their consent as far as the treaty is concerned. The argument here is that the error to invalidate consent to a treaty does not apply if the state's own conduct caused the error, yeah, or if they had actually advanced notice of the error. An error, for example, yeah, to the wording of the treaty does not invalidate the treaty. Look at Article 79. Now, when you look at Article 49, the state, for example, concludes a treaty by what they call, if a state concludes a treaty by what they call fraudulent conduct, or of another participating, it's reason to invalidate the state's consent to a treaty. When you look at Article 50, if a state concludes a treaty by corrupt representative, for example, directly or indirectly by another participating state, it's also a ground to invalidate the state's consent to a treaty. Yeah. When you look at Article 51, if, for example, a state concludes a treaty by a representative who have been coerced, the state's consent to a treaty has no legal effect. Please understand that. And then if you look at Article 52, if a state concludes a treaty by being threatened by the possibility or the use of force that violates, for example, the UN Charter, then the consent of the treaty is actually void. If you look at Article 53, if a norm of general international law that is accepted and recognized by international community conflicts with the treaty, then the treaty is actually void. Look at Article 54. A treaty can actually be terminated by a party, or by a party that can actually withdraw from the treaty as followed in the text of the treaty, or at any time from the consent of all other parties to the treaty. When you look at Article 55, the argument here is that unless specifically mentioned in the treaty, a treaty does not terminate solely for the reason that it does not meet the required number of the parties for its entry into force. Yeah? If you look at Article 56, treaties has no mention of its termination. It is not possible to denounce or withdraw from unless all parties expressly, express the possibility of its termination of being possible. Yeah? Or if the treaty by its nature implies the possibility of its termination. Yeah? Now, if termination is possible, then a party must give at least 12-month notice for its intention to withdraw or denounce the treaty. When you look at Article 57, the argument here is the operation of the treaty must actually be suspended as expressed by the treaty, or at a time from the consent of all the other parties to the treaty. When you look at Article 58, the argument here is suspension of a multilateral treaty by certain parties only. Two parties may actually agree to suspend a multilateral treaty by themselves alone if this possibility is made clear in the treaty, or if the suspension in question is not prohibited by the treaty. Now, the argument here is that the suspension must not affect the rights and the performance of other parties to the treaty, and usually the suspension is only possible if it's not an essential provision of the treaty in accordance with the object and purpose of the treaty, obviously. Yeah. So anything other than the above conditions, the argument is that must be notified by all the other parties to the treaty of their intention to suspend the provisions of the treaty. When you look at Article 59 in terms of termination or suspension of the treaty due to, for example, to application of a later treaty, a treaty will actually be terminated if all the parties conclude that there is a later treaty on the same subject matter that should be governed by by the later treaty, and the current treaty definitely cannot be governed at the same time as the later treaty. Yeah. So a treaty will actually be suspended in operation if mentioned in the later treaty, or parties intend the treaty to be suspended. Now, look at Article 60. Article 60, in terms of termination or suspension of a treaty as a consequence of its breach. If a state, for example, party to a bilateral treaty breaches it, then the other party may have grounds to terminate or even suspend the operation of the treaty in whole or in part. Yeah. So the argument here is that a breach of what they call a multilateral treaty allows the other parties by unanimous agreement, yeah, to terminate or even suspend the entire or even part of the treaty between the parties, or to terminate the relations between the parties and the state that breached it. Please understand that. Now, What also is important to comprehend is that a party specifically affected by the breached state may use this ground, to terminate or even suspend the treaty between it and the breached state. Yeah, and we also have to comprehend that, for example, if the material breach of a treaty may, by a state radically affects the position of every party to the treaty in its performance and obligation, this then allows, a state to use this as a ground to terminate or suspend the operation of the treaty itself. Yeah. Please understand that. Now, the argument here also still is that a material breach means a rejection of its duty to the treaty or a violation of the essential object and purpose of the treaty. Please look at Article 61. And the argument also propounded here is that supervening possibilities in terms of performance. Yeah, if a party, for example, to a treaty cannot perform its obligation due to a permanent disappearance or destruction of an object vital to the performing of the treaty, then the argument here is that it can be a ground for that state to terminate or even withdraw from the treaty. If the impossibility, for example, to perform its obligation is temporary, then it can only be a ground for suspending the operation of the treaty. Yeah? Now, if a party, on the other hand, to a treaty cannot perform its obligation, or it has actually breached any of the obligations of the treaty, or even breached any other international obligation to a party to the treaty, this cannot be a ground to terminate or even withdraw, even suspend the operation of the treaty. Please understand that. Now, when you argue Article 62, the argument here is that fundamental change in circumstances can be looked at in terms of a fundamental change in circumstances from when the treaty was actually concluded. It cannot be ground for terminating or even withdrawing from the treaty unless the circumstances formed an essential basis of the party's consent to a treaty. Please understand that. Or, on the other hand, if the change of circumstances radically changes the obligation to be performed by the party. Please understand that as well. Okay, it's quite heavy stuff and detailed. You have to bear with us in terms of the dispensation of international law in terms of treaties. Now, a fundamental change in terms of circumstances also cannot be, grounds for terminating or withdrawing from the treaty. If the treaty, for example, establishes the boundary, the change is, is the result of the party's breach of obligation of the treaties, or even the party breached any other treaty. When you look at Article 63, the severance of diplomatic or even consular relations does not affect the legal relations between the parties to the treaty also, unless the diplomatic relations between these parties are inseparable in terms of the factor in the functioning of the treaty. Please understand that. And then when you argue Article 64, if a new, peremptory norm of international law in terms of jurisprudence emerges, any current treaty which does not, correlate with the norm will actually be void. Yeah. When you look at Article 65, it talks about the procedure for withdrawal in terms of termination and suspension, and even the invalidity of the treaty with respect to the other arguments. So the party that intends to do so must actually notify all the parties. If the other parties raises no objection after 3 months, then the party that questioned the action can carry out. Okay. So if the parties on one party objected that to that state's intention, then it must be settled through Article 33 of the UN Charter in terms of negotiation, in terms of inquiry, or mediation, or reconciliation, or arbitration, things of ADR, or maybe judicial settlement, or in terms of resort to regional arrangements or other peaceful means. When you look at Article 66, if the dispute is to be settled by virtue of Article 33 of the UN Charter, then a solution is to be reached within 12 months from the date, from the date the objection was made. If not, the objecting state may submit an application to the International Court of Justice for a decision. Then when you argue in terms of Article 67, the notification of Article 65 must be in writing to declare, the treaty to be withdrawn or terminated or even suspended or even rendered invalid, and shall be actually be carried out through an instrument communicated to the other party. And the instrument should actually be signed by the head of state or the head of government or the Minister of Foreign Affairs or a representative demonstrating full powers. Okay, when you look at also Article 68, a notification or instrument provided for under Article 65 to 67 can actually be revoked at any time before it takes effect. When you argue in terms of Article 69, consequences of the invalidity of a treaty in terms of procedure followed successfully in this convention can actually cause a treaty to be invalid with cause that, invalid will cause that treaty to be actually deemed void and even without any legal force. So if after it being rendered invalid, acts were actually performed based on that treaty, then each party may actually need to establish, in their relations, the position that they would have if the act did not actually occur. Okay? And then understand that acts performed in good faith before the treaty was invalid are actually considered lawful based on the treaty as well. Okay? Look at Article 70. Article 70 basically in terms of consequences of termination of a treaty, unless mentioned on the treaty, all parties agree the termination of a treaty under the procedure of this convention in terms of releases, basically releases all parties from the obligation of the treaty. So the argument here is the termination of the treaty does not affect any rights or obligations or legal situations created by the parties involved during the performance of the treaty prior to its what? Termination. That's important. And for example, if a state's party withdraws from a multilateral treaty, for example, before the treaty is terminated, then the termination of obligation of that state to the other parties takes effect from the date that the withdrawal actually did take place. Remember that. When you look at Article 71 in terms of the consequences of the invalidity of a treaty conflicting with what they call peremptory norm of international law, if a treaty is void under Article 53, for example, then the parties shall actually avoid performing any act which conflicts with the peremptory norm of international law and brings their acts in conformity with this norm. So if a treaty is void under Article 64, for example, the treaty is terminated and releases all parties, from their obligations as far as the treaty is concerned. Yeah? Now, please understand that the termination of the treaty in most cases does not affect any rights, obligations, or even legal situations created by the parties involved prior to its termination. Please remember that. Now, if you're arguing in terms of the rights and obligations or even legal situations by the parties that cannot be continued after the treaty's termination, if it conflicts with the new peremptory norm as far as international law is concerned. When you look at Article 72, in terms of the consequences of suspension or even operation of the treaty, unless mentioned on the treaty or even all the parties agree, the suspension of the treaty under the procedure of this convention basically releases all parties from the obligation of the treaty during the period of what? Suspension. Yeah? And the argument here is that the suspension of a treaty does not affect other legal relations between the parties. Yeah? So also understand that during the suspension period, all parties will refrain from acts that seemingly obstruct the treaty to resume. And then if you argue Part 6 in terms of what they call the miscellaneous provisions, specifically under Article 73, the convention in most cases does not prejudge any question that may actually appear in regard of a treaty through state succession or state responsibility or even an outbreak of hostilities. Yeah? When you look at Article 74, for example, severing diplomatic or even consular relations between states does not affect the situation of the treaty or the conclusion of the treaty between the states. Yeah? When you look at Article 75, the convention in most cases shall not prejudice any obligation to a treaty against any aggressor state that took measures in conformity with the United Nations Charter. That's something you must comprehend as well when you're arguing that. Now, let's try to look at what? Part 7 as well. Brace yourselves. It's quite serious business, right? Not so. Part 7, we argue in terms of what they call depositories, notifications, corrections, and even registration. If you look at Article 76, for example, the location of a depository of a treaty will actually be according to where the states on the treaty, or at a location that all the participating states agree. Yeah. So the depository is under obligation to act in accordance with its function. So as it's an international, character. When you look at Article 77 in terms of functions of depositories, the functions of depositories are unless otherwise mentioned in the treaty or otherwise agreed to by the parties, keep the original full text of the treaty. Yeah. And they prepare certified copies of the original full text or even additional languages as required. So the argument here is that receiving signatures to the treaty and keep any documents in relation to it becomes essential. Now, also ensuring the signatures are related to documents are in the right format, and that if they are not, you should notify the concerned state and inform the parties in terms of the participating states of any notices or any communication relating to the treaty. Yeah. Now, when the number of signatures or ratification or acceptances or even approval or accessions have actually reached the required number, you are required to inform all states involved into its entry into force and register the treaty with the Secretariat to the United Nations. Yeah. And the argument is also perform any other functions as mentioned as far as the convention is concerned. If a state, for example, partly feels the depository is not doing its function, then the depository shall bring this to the attention of all parties and participating states, or if not appropriate, a relevant government organization, for example. Look at when you argue Article 78, unless otherwise mentioned in the treaty, Any notification by any state shall actually be submitted to the state intended. Okay, and if there is a depository, it shall be submitted to the depository instead. Okay, now the notification also shall actually be valid if it has actually been received by the depository, or if there is no depository, it shall be valid once received by the state intended. If received, for example, by the depository, the notification is only valid once the depository has actually communicated to the states intended. When you look at Article 79, after the authentication of the treaty, the participating states agree that, for example, it contains an error, unless decided by the agreed means. Yeah, it will actually be corrected. That's simple. So having the appropriate correction made to the text of the treaty in terms of executing a change of instrument or setting out the correction, or executing a corrected version of the whole treaty. So if there is a depository, then the depository will actually notify all the participating states of the error and actually propose to correct it with designated time limit to which objections can actually be made. Okay. Now, if on the expiry, for example, of the time limit, then no objections are raised, then the depository will actually correct the error and communicate a notification, what they call process verbal, to all the participating states. So an objection is, if an objection, for example, is raised, then the depository will actually communicate this objection to all the participating states, and the correction of the treaty will actually be notified to the Secretariat of the United Nations as well, right? When you look at Article 80, once a treaty has actually entered into force, it will be transmitted to the Secretariat of the United Nations for publication. Okay. Now, if you are to argue Part 8 basically talks about what they call the final provisions, and under Article 81, the convention is open to all member states of the United Nations, or any specialized agency or International Atomic Energy Agency, for example, or parties of the Statute of the International Court of Justice. Yeah. It's also open to any state, for example, invited by the General Assembly of the United Nations until that was as far as 30th November 1969 at the Ministry of Foreign Affairs in Austria, or 30th April 1970 at the United Nations in New York. By vacuum, when you look at Article 82, by the way, the convention is subject to ratification. Instruments of ratification are actually, at the United Nations in New York. And when you look at Article 83, the convention is actually open to accession by any state by virtue of Article 81. And if you look at Article 84, the convention will actually enter into force on the 13th day after 35 states have actually acceded or ratified it. When you look at Article 85, the convention is equally authentic in English, Chinese, French, Russian, Spanish, and it shall actually be deposited at the United Nations. And that was basically done way back, if you remember, in terms of argument, way back on 23rd May 1969. So that is something that you may want to comprehend as far as the legal instrument is concerned. Now listen very attentively, okay? Treaties and subjects of international law are fundamental aspects of international relations and law. And so we're going to discuss some in-depth in terms of providing real empirical evidence by referring to some substantive legal authorities and international legal frameworks. I know I've created a strong background in terms of the legal aspect of treaties. But let's first of all break it a little bit down, and please bear with me, as I said, because of the importance of the subject. Now, treaties in international law, by definition, treaties basically are, as I said, they are formal agreements between states or international organizations governed by international law. And they are sometimes referred to as conventions, protocols, or even accords. That's something that you understand on the general perspective. Yeah? Please understand that. Now, I'll try and give some empirical evidence to support the arguments that I'm propounding. In terms of empirical, you may want to look at what they call the Paris Agreement. Formerly, the Paris Agreement, under the United Nations Framework Convention on Climate Change, the treaty was adopted way back in 2015, and its aim was to combat climate change. It involved about 196 parties, making it one of the most significant international agreements in the recent years, perhaps. And if you had to argue that in terms of authoritative discussion, the legal authority for treaties is basically, as I argued ahead, is the Vienna Convention on the Law of Treaties, what some people call VCLT, the Vienna Convention on the Law of Treaties, which was adopted again in 1969 and entered into force in 1980. And this instrument that we discussed above basically codifies the rules and procedures for formation, interpretation, and even termination of treaties. We have been a little bit exhaustive in terms of discussing the entire thing, right? Now, as an international legal instrument, the VCLT is a cornerstone for international legal framework for treaties. As I said, it provides guidelines for treaty formation, for interpretation, for reservation, and even for objections. And it addresses the consequences of breaches and the international termination when it comes to termination of treaties as well. Okay? Another important aspect that we want to comprehend when we talk about this particular subject is what we call customary international law. In addition to obviously treaties and customary international law, which emerge basically from consistent state practice, or even they call opinio juris, a belief that the practice is legally required, basically plays a significant role in terms of international law. Customary law basically is evidenced by what they call state actions over time, yeah, in terms of what gaining what they call notoriety, or they've been notorious over a period of time, yeah. Now, another important aspect you may want to comprehend is subjects of international law, perhaps in terms of this component. You, by definition, when you're arguing subjects of international law, these are basically entities, states and certain international organizations that possess legal personality and can actually participate in international legal relations. We will explain a little bit those if we have the time to do that, depending on how much grace we have to do that. In terms of states as subjects, states are the primary subjects in terms of international law, and they have what they call the full legal personality, and engage in treaties, in diplomatic relations, and even international disputes. That is something that you may want to comprehend as well. Also, if you have to argue in terms of what they call some kind of data to support our argument, the existence and actions of states themselves are actually empirical evidence of their subjectivity. For example, you could argue that maybe the United States participation in various international treaties and agreements demonstrates its status as a subject of international law for argument's sake anyway. That will bring out what we're trying to say. If you are to look at authority to back up our dispensation up there, the legal authority in terms of the status of the states as subject to international law is a principle of what they call sovereign equality, yeah, which is enshrined again in the United Nations Charter when you look at Article 2, Subarticle 1. And this principle establishes that all states, regardless of size or power, have equal legal standing. That's the question of debate for those of you who may comprehend what's happening in the world today. Not so. If you are to argue in terms of international legal framework, the argument here, you may want to look at what they call the Montevideo Convention on the Rights and Duties of States, which was adopted in 1933, which provides for the criteria for a statehood as defined in terms of a territory as a permanent population, a government, and and the capacity to enter into relations with other states. And that is something that you may want to comprehend still. Now, you may also want to comprehend what they call international organization, where we are saying that certain international organizations, such as United Nations and the International Committee, for example, Red Cross, also have subjectivity in terms of international law, allowing them to engage in treaty making and other international activities. That is something, again, that's also important for discussion. Then, if you are to argue in terms of what they call the intersection of treaties and subject, then it's important for us to note that here, treaties, basically what happens is that treaties become primarily means by which subjects of international law, especially states, engage with each other to establish what they call binding obligations. Yeah, and that is something you must understand. So, when you're arguing that, then you have to understand that subjects of international law would include states becoming parties to treaties voluntarily, and their consent to be bound by a treaty is a fundamental principle of law. Okay, you have to look at Article 2, okay, of the convention, of the Vienna Convention as well. Now, also, if you have to argue in terms of the fact that states use treaties to regulate various aspects of their relations from trade, for example, you would argue in terms of the WTO agreement, or to even in terms of the International Convention on Civil and Political Rights as far as human rights are concerned. Yeah, that's something that you may also want to comprehend in terms of the applicability or the practicability of it. Yeah. So the argument here is that subject to international law, for example, when they sign and ratify treaties, they usually undertake legal obligations under international law, and compliance with these obligations becomes vital for the stability and the effectiveness of the international legal system. as I just pointed out. Now, even as we continue, please understand that treaties and subjects of international law are an integral component of international legal system. So the point is that treaties basically are, form agreements that regulate state behavior, and subjects of international law, primarily states, are the primary participants in international legal relations. So the empirical empirical evidence of their existence and activities can actually be found, as I said, in numerous international agreements and diplomatic relations, while the legal authorities and frameworks such as the Vienna Convention, obviously the VCLT, and the Montevideo Convention govern their formation and status. Super important aspect that you need to comprehend right over there. Okay, now let's talk a little bit about the importance of treaties in international relations. How important they can be. You could argue in terms of what they call conflict resolution. Treaties play a very vital role in preventing and even resolving conflicts among states. For instance, the United Nations Charter itself is a treaty that establishes the framework for peaceful dispute in terms of settlement through International Court of Justice. That is something that you must comprehend again from the word go. Then if you have to argue in terms of another use, you look at it in terms of promotion of cooperation. Treaties usually promote what they call cooperation among states in various areas such as trade or even environmental protection and human rights. And examples would include trade agreements like the North American Free Trade Agreement, for example, what they call the NAFTA, and regional human rights conventions such as European Convention on Human Rights, for example. You want to also look at it in that context as well. It becomes another super important thing to look at. Then they also have another advantage in terms of what they call global problem solvers or global problem solving. In terms of global challenges such as climate change and transnational crime, for example, so often require what they call collective action. So treaties provide a mechanism for states to work together to address these issues. So I'll give an example in terms of what they call the Kyoto Protocol, and the United Nations Convention against transnational organized crime, for example, or what they call the Palermo Convention. Those are some illustrations that will bring out the point they're trying to say. Another is, you may want to look at it, how treaties benefit states in terms of an argument. How do treaties benefit states generally? They may benefit states in terms of what they call legal certainty. Treaties basically provide legal certainty by establishing what they call clear rules and obligations. So what happens is that states can actually predict how others will behave in a given situation in terms of reducing uncertainty and potential conflicts. That is another aspect that you need to comprehend. Then also in terms of what they call mutual benefits, states enter into treaties because they believe that they will benefit from them. So treaties often involve a give and take negotiation process where states actually exchange what they call concessions to achieve common goals. That's another aspect that you may want to comprehend as far as that is concerned. You also may want to look at it in terms of what they call enhancing what they call repetition. The compliance with treaties enhances a state's reputation and credibility in international community. It demonstrates a commitment to international norms and even values. So again, that's another super important aspect that you want to comprehend. In terms of contemporary challenge and developments, as far as treaties are concerned, something that you may want to argue or to look at is what they call materialism versus bilateral terrorism. Here we're arguing that states increasingly engage in both multilateral and even bilateral treaty making. Multilateral treaties involve obviously multiple parties and address global issues, while bilateral treaties are agreements between two states. So that's something you want to comprehend. And in terms of challenge to treaty compliance, we will comprehend that some states may actually face challenges in fully complying with treaty obligation due to domestic constraints. Changing political landscapes, for example, or even resource limitations. So the argument of enforcement in terms of enforcement mechanism, such as maybe dispute settlement procedures, are designed to address non-compliance in that perspective. Now, if you have to argue treaties in terms of emerging areas, you may also want to comprehend the fact that new areas of international cooperation, such as cyberspace, for example, or even outer space, present challenges for treaty law. And states are actually exploring the need for treaties to govern these domains. and that is something that you must look at as a substantive growing area. In terms of challenging, or perhaps in terms of challenges as far as implementation or even enforcement of treaties, you would be quick to comprehend that there is what they call selective compliance. The argument here is that states may actually selectively comply with treaty obligations, choosing to implement some provisions while ignoring others. And this has basically weakened the effectiveness of the treaties overall. And that is something you must comprehend as well, again, from the word go. Yeah. Also, another complaint or perhaps challenge would be in terms of lack of enforcement. The argument here is that the enforcement of treaty obligation relies on state consent, and therefore, and there may be instances, for example, where states refuse to participate in dispute, settlement mechanism, or to comply with what they call adverse judgments, and that becomes a question of concern, really. So we have to point it out again as another challenge. Another would be in terms of what they call challenging political dynamics. Yeah, political changes, for example, including regime changes in states, usually lead to shifts in what they call treaty commitment and foreign policy priorities. So that is something that, again, that you cannot leave out, again. So the argument here is that treaties are essential instruments, as I said, in terms of international law, that facilitate cooperation, conflict resolution, basically, also for the promotion of common goals, among states. And the argument also, importantly, is that they actually provide legal certainty and benefit to states, although we've seen that although challenges in compliance and enforcement do really persist. So the argument also can be presented in the sense that the dynamic nature of the international relations continue to shape the treaty landscape, with states adapting to emerging issues and even evolving political dynamics. So the empirical evidence of treaties and their impact can actually be observed in a wide range of international agreements that regulate various aspects of state behavior and international relations as well. So when you're arguing legal authorities and frameworks, you may want to also, both customary and even codified, these set a guide in terms of formation and interpretation of treaties, ensuring their role as key components of the international legal system. And that's something that you may want to comprehend. I'm not sure if we talked about something to do with customary international law and treaties. Maybe we did, but if we are to argue a little bit of that in terms of dispensation of our discourse here, customary international law is another important source of international law alongside treaties. Yeah, and therefore customary law basically raises from state practice and what they call opinio juris, the belief that certain practice is legally required, while treaties are explicit agreements in terms of customary law that evolve gradually over time. And that is something that you might want to understand. But perhaps to emphasize that point, customary law and treaties can actually complement or conflict with each other. And customary law can actually fill gaps in treaty law and even provide what they call additional norms. For example, the prohibition against torture is usually a customary norm, supported by numerous state practices and even treaties as well. That is something you may want to understand. And the argument also here is that treaties can also codify or even crystallize what they call existing customary norms. So when states, for example, codify a customary norm into a treaty, it strengthens the norm and actually makes it more legally binding in terms of authenticity. So that is something that you may want to comprehend again in terms of that. If we are to argue a little bit of international legal framework for treaty making, I know we've given ourselves a very strong background, but let me just conclude by pointing out a little bit of that. The Vienna Convention, remember, the Vienna Convention becomes the locus classicus. The Vienna Convention on the Law of Treaties of 1969 is the primary international legal instrument in terms of governing the formation and interpretation of treaties. And as I said, it codifies many customary practices that are related to to the treaties. And as I said, please pay specific attention to Article 2 of the Vienna Convention that defines the treaty as an international agreement concluded between states in written form and governed by international law. So this definition is actually widely accepted and even applied in terms of that particular component. Then you may also want to comprehend that the Vienna Convention also addresses issues, as I said, as far as treaty formation, reservation, interpretation, and termination, providing clarity in terms of rules of these aspects of treaty law. We went at depth to try to go through some of those arguments. Now, I know that we may argue in terms of substantive empirical evidence or case studies for that effect. Yeah, I know I pointed out some, but for a purpose of emphasis, empirical evidence in terms of importance or impact of treaties can actually be found in various case studies in terms of real world examples. For instance, as I said, the Paris Agreement, which aims to combat climate change. Remember, we talked about that. That has definitely had its impact in terms of reducing what they call greenhouse emissions. Not so. Then you may want to look at the Chemical Weapons Convention as well. Is another example of a treaty that has actually successfully led to the destruction of stockpiles of chemical weapons and prevented their use as well. Yeah. You also may want to look at other aspects in as far as other examples that play out in terms of what they call the WTO, the World Trade Organization, as another play out of a treaty in action. In terms of overseas numerous trade agreements that have actually facilitated global trade and reduced trade barriers. Yeah, that's another one that you may want to comprehend. You may also want to look at the United Nations Conventions on the Law of the Sea, what they call the UNCLOS. Yeah, that has actually established a comprehensive legal framework for the world's oceans, including rules on territorial waters, exclusive economic zones, and exploitation of what they call marine resources. That's another aspect that you may want to comprehend as well as another play out. So the argument here is that in case of disputes that are related to treaty interpretation or compliance, as I said, the states often bring cases before the International Court and Tribunal, such as the International Court of Justice, what some people call the ICJ, or even the WTO's dispute settlement body, providing for further as another evidential in terms of how the play out of the treaties in terms of international dispute resolution, in terms of a play out. So that again becomes extremely important for us to know and to understand. Now, we may want to pose a little bit of challenges and criticism that may have relate to treaties as a subject of of debate. Some critics argue that treaties can actually be used by powerful states to impose their will on the weaker states. Yeah, and they highlight instances where, for example, powerful countries have actually not ratified or even complied with certain treaties, for example, and I think that's very common in the world of today. So basically, undermining the principle of equality among states is a question of serious debate. And then you may also want to comprehend the fact that negotiations and implementation of treaties can actually be slow and even complex, leading to delays in terms of addressing what they call urgent global issues. Yeah, and the point here is that the issue of, for example, treaty withdrawal, as seen in cases like the withdrawal of the United States from the so-called Paris Agreement, raises questions about the stability and effectiveness of international agreements. Yeah, and that's something you may want to think about as well in terms of the effectiveness of these so-called treaties. So the point here, friends, is that treaties are essential instruments of international law that shape the state behavior and foster cooperation and address what they call global challenges. And they exist, as I said, within legal framework governed by international law, including, no doubt, the Vienna Convention on the Law of Treaties. And as I said, empirical evidence from various international agreements and case studies demonstrate their significance in terms of contemporary international relations. But as I said, challenges and criticisms also highlight areas where improvement and reform may need to be to be occasioned. Ultimately, treaties no doubt remain a cornerstone as far as international legal systems are concerned, in terms of reflecting the shared interest and also commitment of states in an interconnected world as of today. So that again becomes very, very important in terms of understanding that. I wouldn't want to go so much, but maybe I'm tempted to talk about contemporary issues and evolving treaty law as another aspect, because we have to look a little bit ahead. If you had argued in terms of contemporary international relations continue to be shaped by negotiations and even implementations of treaties. And one of the most pressing issues today is actually climate change. For example, if you're arguing in terms of the Paris Agreement, it remains a focal point in terms of international efforts to combat global warming, which is a serious problem, by the way. So we need to comprehend in terms of the continuity of the enforceability of some of the treaties. Now, treaties are also instrumental in addressing public health crises, for example, as seen in the response of COVID-19 pandemic, for example. Countries have actually entered into agreements and even arrangements to ensure what they call equitable access to vaccines and even medical supplies. Yeah, and this is something again that is important for us to comprehend as an aspect of continuity. Then you could also argue in terms of what they call human rights treaties, such as the Universal Declaration of Human Rights, yeah, and and the International Covenant on Civil and Political Rights. And the point here is that these play a crucial role in terms of promoting and even protecting human rights worldwide. And they function as monitoring bodies and mechanisms established by these treaties to hold treaties or rather states accountable for their human rights obligations. Yeah, so that's something again you cannot do away. It becomes extremely important. Then we also have treaties related to disarmament and non-proliferation, for example, such as the Treaty on Non-Proliferation of Nuclear Weapons, what they call the NPT, and the Chemical Weapons Convention, for example. These continue to be critical in terms of preventing the spread of weapons of mass destruction, as they say. Okay, and that's something that's extremely important as a continuity as well when you're arguing the law of treaties as well. So and then you could also look at it this way in terms of treaties. Trade treaties and organizations like World Trade Organization, for example, are essential for facilitating global commerce, although they also face challenges in terms of related to protectionism and even trade disputes, for example. Yeah, and that's something again that you may want to understand. So friends, even as we argue, we could go on and on, but I would like to say that that is a brief in terms of some of the things that have to do with the law of treaties. I will consider this section or volume or audio 1 that argue for you treaties generally. When we come back, God willing, we'll do our second version in terms of comprehending some of the other issues that have to do international that may be crucial for our dispensation in terms of demystifying the concept of international law. Once again, my name is Isaac Christopher Lubogo. Please find most of our material at lubogo.org or suigenerislaw.com. Consider this volume or section or version 1 in terms of the law of treaties, in terms of the entirety as a discussion, as we've just been had. I'll exit and hopefully, with the grace of God, come back with a second discussion in terms of another component of international law. Thank you and God bless you. Thank you.